Hi, this is Anita Josiah, Program Coordinator for Cook County and Home Support Program. In this presentation, we'll be talking about maltreatment of minors. Although we don't often come into contact with minors while providing services to in-home support program service recipients, there can be an occasion, for instance, where a grandchild is in the home while you're providing services, or you witness something in the hallway of a participant's apartment building. We will be discussing what constitutes maltreatment and the process for you as mandated reporters for making a child protection report. What constitutes maltreatment of minors? According to Minnesota statutory definitions, the 5 areas of maltreatment listed here and the definitions that will follow provide clarity on how abuse and neglect are defined by Minnesota law. However, if you are ever in doubt about a situation, it is best to make a child protection report and let the experts determine whether or not it is indeed maltreatment. We will be talking about physical abuse, sexual abuse, mental injury, neglect, and threatened injury. According to Minnesota state law, physical abuse as it relates to child maltreatment is defined as when a parent, guardian, or other person responsible for the child's care hurts the child, causing any physical injury other than by accidental means. Examples include, but are not limited to, throwing, kicking, burning, biting or cutting the child, striking the child with a closed fist, shaking a child under age 3, unreasonable interference with the child's breathing, threatening the child with a weapon, or purposely giving poison, alcohol, or dangerous, harmful, or controlled substances which were not prescribed for the child by a practitioner in order to control or punish the child. Child sexual abuse is sexual conduct, including threatened sexual abuse, with a child by a person responsible for the child's care or by a person who has a significant relationship to the child. And this can include child pornography and even sex trafficking. Mental injury is an injury to the psychological capacity or emotional stability of a child, as evidenced by an observable or substantial impairment in the child's ability to function within a normal range of performance and behavior with due regard to the child's culture. With neglect, the most common form of maltreatment, the harm results from what the parent or caretaker fails to do to provide a child with needed care and protection. Usually, this failure is in supplying the child with necessary food, clothing, shelter, medical or mental health care, or appropriate supervision. It's also the failure to protect the child from conditions or actions that might endanger the child. A 5th area of child maltreatment, according to Minnesota law, is threatened injury. Threatened injury can be a statement, overt act, condition, or status that represents a substantial risk of physical or sexual abuse or mental injury. Some examples would be threatening a child with a weapon, allowing a child to ride in a vehicle with an intoxicated person, or an act that results in the involuntary transfer of permanent legal and physical custody of a child to a relative. The following video was recommended by social worker Heidi Akins, who works very closely with child maltreatment cases in Cook County. This video is officially produced by Minnesota Department of Human Services.
Welcome to Mandated Reporter Training Child Protection Response. This video reviews what information you should have prepared at the time of making a child maltreatment report and what steps the local child welfare agency will take next. The first step is gathering information from the reporter, which the local child welfare agency refers to as intake. What will you be asked? Information gained from reporters is essential for the best screening decisions possible. The child protection intake worker may request the following information: your name, phone number, your relationship to the family or child, and source of information, what you witnessed, heard, and so forth. You may be asked the name, address, age, and other identifying information regarding the alleged victim, siblings, alleged offender, other household members, or any additional witnesses. You may be asked specific description of the allegations, when and where the alleged incident occurred, and if a child is in immediate danger. You may be asked for a description of a child's injuries or present conditions, and your understanding of the impact of the alleged maltreatment to the child. You may be asked about the presence of domestic violence, criminal activity, including prostitution or sex trafficking of children, weapons, or other dangerous activities in the home. You may be asked for a description of any action specifically in response to the incident, and whether you, as the reporter, would like to be notified of the initial disposition. The child protection intake worker will attempt to solicit as much information that you know about the family and the alleged maltreatment to make the best, most informed decision possible. Therefore, an intake worker's questions may go beyond the examples provided in this training. Although you may not have knowledge or answers to all questions asked, respond to the best of your ability. Be prepared with as many details as possible when making the report to the local child welfare agency. What happens after a maltreatment report is made? Local welfare agency staff may contact other people with knowledge of the child and/or family for additional information. They may also consider past reports and history of social services involvement. Once a report is made, the local child welfare agency makes a decision within 24 hours whether the report meets the legal criteria for a child protection assessment or investigation. This process is called screening. The local child welfare agency staff considers 3 elements in making their decision. 1. Whether the allegation meets the statutory definition of child maltreatment according to Minnesota Statute Section 626.556. 2. There is sufficient identifying information to attempt to locate the child or at least one member of the family. And 3. The report contains maltreatment allegations that have not been previously assessed. Local welfare agency staff may contact other people with knowledge of the child and/or family for additional information. They may also consider past reports and history of social services involvement. Non-discrimination in screening. Local child welfare agency workers will remain aware of the impact that historical trauma and current war trauma has for families of color and American Indian families who become involved with the child protection system. Accepted child-rearing practices of the culture in which a child participates and accepted discipline practices which are not injurious to a child's health, welfare, and safety are taken into account. Local child welfare agencies use Minnesota Statute Section 626.556 alongside Minnesota's Intake, Screening, and Response Path Guidelines, DHS 5144, to ground their decision-making. When a report is screened in, it is assigned to one of the following child protection response paths. All the response paths are non-voluntary responses. Child safety is the paramount concern for all the response paths. The goals of child protection are to help achieve positive outcomes for children and their families. The following describes the components of a family investigation response, a family assessment response, and a facility investigation response. Family investigations are assigned to the most serious reports of harm and neglect. Reports involving substantial child endangerment, as well as sexual abuse reports, must receive an investigation response. Family investigations center on gathering facts, assessing or evaluating risk for subsequent child maltreatment, and assessing family protective capacities related to child safety. A determination is made whether child maltreatment occurred and whether child protective services are needed. Family assessment is assigned to reports not involving substantial child endangerment, sexual abuse, or other situations of serious danger. Family assessment focuses on assessing and/or evaluating risk and engaging a family's protective capacities and offering services. A decision is made if ongoing child protective services are needed or if family support services are jointly agreed upon. Facility investigations are assigned when allegations of maltreatment involve children being served by licensed or unlicensed family child care providers, foster care providers, unlicensed personal care providers, and legally unlicensed child care by a person as an ongoing arrangement, whether paid or unpaid. At the conclusion of a facility investigation, the following decisions are made: whether child maltreatment occurred, a staff person was responsible, a facility was responsible, or child protective services are needed. Screened out reports. When a report does not meet statutory criteria, some reports may still receive a child welfare response or an offer of voluntary services. The following reports require a child welfare response under Minnesota Statute Section 626.556. Sexually exploited youth, child crime victim, and prenatal exposure prior to birth. In other situations, an offer of services can be made under the following program areas: the Parent Support Outreach Program, Child Welfare, Children's Mental Health, and Chemical Dependency. The local welfare agency may also refer the family or reporter to other available services or resources in the area. Some reports are referred to another lead agency, such as the Department of Human Services Licensing Division, while others do not require any further follow-up by any agency. All screened-out reports are maintained in the agency's database for 5 years. Once an assessment or an investigation is completed, limited information may be provided to a reporter. Privacy laws limit information that can be disclosed. Mandated reporters can be informed of whether the report has been accepted for assessment or investigation. If accepted, in most circumstances, a reporter can receive a written summary of the conclusion of the assessment or investigation. Voluntary reporters will be informed only if they request it, limited to an agency's response to the report or a statement regarding child protectives are being provided. For more information regarding mandated reporting, the Department's Reporting Child Abuse and Neglect, a resource guide for mandated reporters, has additional information. The guide can be found on the Department's website at http://mn.gov/DHS. Here are the state statutes and guidelines for mandated reporters. The Reporting of Maltreatment of Minors Act, Minnesota Statute Section 626.556. The statute governing reporting of prenatal exposure to controlled substances, Minnesota Statute Section 626.5561. The statute regarding the definition of child in need of protection or services, CHIPS, Minnesota Statute Section 260C.007, Subdivision 6. The Administrative Rule governing disclosure of records, Minnesota Administrative Rule 9560.0230. The federal statute governing Indian children in the child welfare system, Indian Child Welfare Act, ICWA, 25 USC 1901 ETSEQ. The state statute governing Indian children in the child welfare system, Minnesota Statute Section 260.762, and the Resource Guide for Mandated Reporters of Child Maltreatment Concerns. For more information on all child maltreatment guidelines, see Minnesota Child Maltreatment Intake Screening Response Path Guidelines. This has been Mandated Reporter Training Child Protection Response. Please see the Mandated Reporter Guide available online for more information.
Here you see the in-home support program, Maltreatment of Minors Mandated Reporting Policy. This same policy is followed by all providers licensed by the Minnesota Department of Human Services. Who should report Any person may voluntarily report abuse or neglect, but we, as people who work for a Minnesota licensed program, are mandated to report and cannot shift the responsibility of reporting to anyone else, such as our supervisor or anyone else at the Public Health and Human Services, for instance. If you know or have reason to believe a child is being or has been neglected or physically or sexually abused within the preceding 3 years, you must within 24 hours make a report to an outside agency. So, where to report? If you know or suspect that a child is in immediate danger, call 911. Don't take your time, just call 911. Reports concerning suspected abuse or neglect of children occurring in a licensed child care, foster care, or child care facility would be made directly to Cook County Public Health and Human Services, the County Child Protection Services. Reports concerning suspected abuse or neglect of children occurring in any other facilities licensed by Minnesota Department of Human Services should be made directly to the Department of Human Services maltreatment intake line at 651 431 6600. Reports regarding incidents of suspected abuse or neglect of children occurring within a family or in the community, again, should be made to the county or to local law enforcement. County's number is 218-387-3620, law enforcement 387-3030. If your report does not actually involve possible abuse or neglect, but does involve possible violations of Minnesota statutes or rules that govern a particular facility, you should call the Department of Human Services Licensing Division at 651 431 6500. So let's say you have witnessed or suspect maltreatment of a child. What do you report? So we've talked about definitions of maltreatment to some extent. You can get that in more detail if you search out Minnesota statutes, section 626.556. A report to any of the above agencies should contain enough information to identify the child involved, as well as any persons responsible for the neglect or abuse if known, and the nature and extent of the maltreatment and or possible licensing violations. For reports concerning suspected abuse or neglect occurring within a licensed facility, the report should also include any actions taken by the facility in response to the incident. So an oral report of suspected abuse or neglect made to one of these agencies by a mandated reporter must be followed up by a written report to the same agency within 72 hours, not counting weekends or holidays. But what if you are a mandated reporter and you witness abuse or neglect? If you know or have reason to believe that a child has been neglected or abused physically or sexually and fail to report, it's actually a misdemeanor. If a mandated reporter who fails to report maltreatment that's found to be serious or recurring may be disqualified from employment in positions allowing direct contact with persons receiving services from programs that are licensed by the Department of Human Services or the Department of Health. So if you are making a report, say, about the agency, an agency, a program, that the employer, it's your own employer. Let's say you're making the report about someone here at the facility at Cook County Public Health and Human Services. Um, your employer cannot retaliate against the mandated reporter for reports made in good faith or against a child who is the subject of the report. The Reporting of Maltreatment of Minors Act contains specific provisions regarding civil actions that can be initiated by mandated reporters who believe that retaliation has occurred. Once there has been a report, there will be an internal review, and the facility must complete the internal review according to Minnesota law within 30 days and take corrective action if necessary to protect the health and safety of children in care. The internal review must include an evaluation of whether
related policies and procedures were followed, those policies and procedures were adequate, whether maybe there's a need for additional staff training, if the reported event is similar to past events with the children or the services involved, and if there's a need for corrective action by the license holder to protect the health and safety of children in care. Primary and secondary person or position to ensure reviews are completed. As far as in-home support, the internal review would be completed by myself, Anita Josiah, as the in-home support designated coordinator. If I'm involved in the alleged or suspected maltreatment or unavailable on vacation or something like that, then my supervisor, Martina Johnson, who is the program designated manager and the adult and home and community-based services supervisor, would be notified, or Grace Bouchard, children's services supervisor, would be the one responsible for completing the internal review. Any of us can be reached at the main number noted above, 218-387-3620. Documentation of internal review. The facility must document completion of the internal review and make those reviews accessible to the commissioner if the commissioner requests it. And then again, any corrective action plan. Based on the results of the internal review, the license holder must develop, document, and implement a corrective action plan designed to correct current lapses and prevent future lapses in performance by individuals or the license holder, if any. And that could include service provider training. We do provide annual training on the Reporting of Maltreatment of Minors Act every year. And then that is, again, this policy here is going to be in your in-home support program service provider information and policy manual, so you can refer to it again there. And then I also document it in your personnel record each year when you've received this training. Facilities that work with children are required to provide the policy, their mandated reporting policy, to the parents at the time that the children are enrolled in their program, and have to have it available upon request as well. In summary, briefly, as caregivers, we are mandated reporters of potential maltreatment of minors per Minnesota law, and that is Minnesota Statutes Section 626.556. Maltreatment of minors may consist of physical abuse, sexual abuse, mental injury, neglect, or threatened injury. Intervention and prevention efforts must address immediate concerns for child safety and ongoing risk of abuse or neglect. Reports are made to prevent harm, to assist families in receiving services, and because it's the law. If a child is in immediate danger, law enforcement must be contacted immediately by calling 911. But if it's not immediate danger, reports may be made to the local county social services, which is Cook County Public Health and Human Services, or to law enforcement. And those numbers are 218-387-3620 for the county, or 218-387-3030 for law enforcement. If we as mandated reporters fail to report suspected abuse or neglect, it's a misdemeanor. If we fail to report maltreatment that's found to be serious or recurring, we could be disqualified from employment in positions that allow direct contact with individuals that are licensed by the Department of Human Services or Department of Health. And a mandated reporter's identity is confidential. Thank you so much for taking this training, for being who you are, for caring for the people that we serve, and just always being on the alert for any harm that can come to people in our community. You are very appreciated. Thank you.